Imagine being round up in the middle of the night and with just the clothes on your back, to be shipped off somewhere without your knowledge or permission. Well, this is what happens to the case of Villavicencio versus Lukban. Disclaimer: our videos on laws are based on actual cases. The facts stated have been made public through publications. Therefore, should any details, especially on petitioners, defendants, and or the defendant accused, offensive in any way whatsoever, kindly leave a message or comment in our Facebook and we'll be more happy to oblige to change any details accordingly. Trying to get rid or preserve the rampant prostitution of jurisdiction, the Mayor of Manila, Justo Lukban, with the best of all reasons, ordered the segregated district of Manila for women of ill reputations or prostitutes, which had been permitted for a number of years to be closed. These women were kept confined to their houses in the district by the police. Presumably, during this period, the city authorities quietly perfected arrangements with the Bureau of Labor to sending the women to Davao in Mindanao as laborers, with some government office for the use of Coast Guard cutters, corregidor, and negros, and with the constabulary for the guards of soldiers. About midnight on October 25, the police, under orders of Anton Hoffman in the mayor city of Manila, Justo Lukban, descended upon the houses, hustled some 170 women into patrol wagons, and placed them aboard the steamers that awaited their arrival. These women were given the opportunity to collect their belongings and apparently were under the impression that they were being taken to a police station for investigation. They have no knowledge that they were destined for a life in Mindanao. They have not been asked if they wish to depart from that region and had neither directly nor indirectly given the consent to the deportation. The involuntary guests were received on board the steamers by a representative of the Bureau of Labor and a detachment of constabulary soldiers. The two steamers, with their unwilling passengers, sailed for Davao. Generally, some of the women were married, others assumed more or less with clandestine relationships, others went to work in different capacities, or assumed a life unknown and disappeared. Fortunately, a good portion found means to return to Manila. The attorney for the relatives and friends of the considerable number of the deportees presented an application for habeas corpus to the Supreme Court and alleged that the women were illegally restrained of their liberty by Justo Lukban, Mayor of the City of Manila, Anton Hoffman, Chief of Police of the City of Manila. The main issue now is whether or not Mayor Lukban was justified in taking the 170 women and bringing them to Mindanao. The Supreme Court says one can search in vain for any law, order, or regulations which even hints that the Mayor City of Manila or the Chief of Police has the right to force citizens of the Philippine Islands, and these women, despite their being in a sense of lepers of society, are nevertheless not chattels, but Philippine citizens protected by the same constitutional guarantees as are other citizens to change their domicile from Manila to another locality. On the contrary, Philippine penal law specifically punish any public officers who, not being expressly authorized by the law or regulations, compels any persons to change his residence. Law defines power. Centuries ago, Magna Carta decreed that no freeman shall be taken or imprisoned or be seized of his freehold, or liberties or free customs, or be outlawed or exiled, or any otherwise destroyed, nor will we pass upon him nor condemn him, but by law, judgment of his peers, or by the law of the land. We will sell to no man, we will not deny or defer to any man either justice or right. No official, no matter how high, is above the law. The courts are the forum which functionate to safeguard the individual liberty and to punish official transgressors. The law is the only supreme power in our system of government, and every man whom, by accepting office, participate in its functions is only more strongly bound to submit to that supremacy, and to observe the limitations which it imposes upon the exercise of the authority which it gives. The very idea of the same high tribunal, in another case, that one man may be compelled to hold his life or means of living or any material rights to essential enjoyment of life in the mere will of another, seems to be intolerable in any country where freedom prevails, as being the essence of slavery itself. We believe in true principle that if the respondent is within the jurisdiction of the court and it has the power to obey the orders of the court, Thus, to undo the wrong that he has inflicted, he should be compelled to do so, even if the party to whom the writ is addressed has illegally parted with the custody of a person before the application for the writ is no reason why the writ should not be issued. If the mayor and the chief of police, acting under authority of law, could deport these women from the city of Manila to Davao, the same officials must necessarily have the same means to return them from Davao to Manila. The respondents within the reach of process may not be permitted to restrain a fellow citizen of her liberty by forcing her to change her domicile and to avow the act with impunity in the courts. While the person who has lost her birthright of liberty has no effective recourse, the great writ of liberty may not thus be easily evaded.